Hi, everybody. Good afternoon. My name's Elliott Simcoe. I'm a partner with Smart & Bigger in Ottawa. Smart & Bigger is Canada's largest intellectual property firm. We have offices in Montreal, Ottawa, Toronto, Vancouver, and Calgary. And I'm just one of those really lucky people. I get up every morning, I get a chance to work with some really smart people, doing work for some amazing clients, including some of the clients you see up here. I really love getting invited to speak at opportunities like this, because what I'm trying to do is give you some tips and give you some pointers about how to take your companies, which are usually small and medium-sized enterprises locally here in Canada, and grow them to be companies as large as Microsoft, Qualcomm, Instagram, Google, and others. So how do we do that? Well, we start by learning about a little bit about some case histories and how we can learn from them. So who's this? Who's this person that I have up here? Well, her name is actually Catherine Hettinger. And if you read the internet, there's a bit of a controversy right now, but it seems that she is the inventor of the fidget spinner. And the fidget spinner, as those of you who have kids as I do, is the coolest thing right now. Everybody's talking about the fidget spinner. And apparently, she was the inventor of the fidget spinner. Her daughter had some issues with attention deficit disorder, and there's her daughter up on the screen, and she invented the fidget spinner to help her daughter out. She obtained a patent on the fidget spinner. You'd think she would just be raking in the royalties and the licensing fees right now, that she held on to that patent as a lottery ticket and is finally paid off. Unfortunately, that's not what happened. After having a lot of difficulty securing somebody to manufacture the product, she gave up in about 2005. She didn't pay about a $500 maintenance fee to renew the patent, and it went into the public domain. And now somebody else scooped up the invention, and they're the ones taking advantage of it. So the point of today's presentation is, how do you add value to change? She did a great job with change, but how do you add value to that change? So today's presentation is really focused on three areas. Number one, we're going to give you sort of a baseline introduction to the different forms of intellectual property. And then I'm going to talk about two things I want everybody to remember about patents, and two things I want everybody to remember about trademarks. In fact, if these are the only things that you remember from my presentation today, I'm going to be really happy and feel like I've succeeded. And then I want to talk about the difference between invention and innovation, and how to take your company and ensure you won't end up like Ms. Hettinger, who was great with invention, but not so great with innovation. So certainly the most well-known aspects of intellectual property, the ones everybody's heard of course, are patents. I'm a patent guy. I'm proud to be a patent guy. I get up in the morning and I get to work on inventions for great companies doing some really interesting things in the telecommunications area. I do some work in manufacturing, mechanical engineering, and the like, and I secure patents for these companies. Well, certainly patents are new and useful articles of manufacture, methods, processes, and the like, and I'm sure everybody's familiar with that. Copyright, another really important aspect to intellectual property, and some of the teams that have been hearing their updates, certainly copyright is very, very important. There we protect literary, dramatic, musical works. Again, I have this great job. So one of my jobs is when the Bank of Canada comes out with a new banknote, and I'm sure you've seen that we're coming out with a new $10 bill. The Bank of Canada is coming out with a new $10 bill to commemorate Canada's 150th anniversary. Whenever the Bank of Canada comes out with a new banknote, I get a phone call and I get asked to do copyright clearance, because they want to put images, pictures of people, scenes, and the like on those bills, including the ones that are in your wallet right now. It's just a great job because I get to go down to the Bank of Canada. There's a vault. They let me inside. I get to see what an early design of the bill is, and I start to talk about clearance of copyright issues. So copyright's an incredibly important and fundamental aspect of the intellectual property strategy of any company. Trademarks, really, really important. There we're talking about phrases, symbols, designs that connect in the minds of a consumer the source of the goods connect the mark to the source of the goods. Why is it when you're driving down the 401 late at night and you're a little tired, you figure you're not going to make it to Toronto, you see that sign off the highway, maybe a Holiday Inn, a Quality Inn, a Best Western, a Marriott, and it connects in your mind exactly what you can expect as far as the source of the particular service. You get off the highway and you make your choice based on your expectations. So a trademark can be an incredibly valuable connector between the consumer, the potential consumer, and the purveyor of the product or service. Designs. Well, designs protect the look and feel of articles, and certainly in the smartphone industry, the design protection is incredibly important. I'm sure you've heard about the significant litigation between Apple and Samsung in connection with design patents pertaining to the iPhone and the Samsung Galaxy series of smartphones, and certainly that's an example where Apple is enforcing its rights against Samsung to prevent Samsung from allegedly taking advantage of the design protection that Apple has in its smartphones. Trade secrets. Again, an incredibly important aspect to any intellectual property strategy. You don't have to register your intellectual property. It isn't essential. You can keep it a secret. So trade secrets have a very, very broad definition. You need to be thinking about any sort of commercial advantage for an enterprise. So it could be your customer lists, your prospective customers, the sales that you're going to make, your manufacturing processes, all sorts of things. But trade secret protection is only valuable if you keep it a secret. So here you go. I'm going to share with you something right here. Be very careful with your trade secrets because they could go out into the public domain. What are we looking at here? Well, this is the recipe book, apparently, that was shown in about the 1920s in Atlanta to a very secret formula. It was shown to the Atlanta Hartfield Constitution, the newspaper in Atlanta, of a very secret formula. A photograph was taken. The photograph was put in the archives in the vault of the newspaper, and then it was unearthed about 5-6 years ago, again according to the internet, and published. That is the recipe for Coca-Cola. There it is. I know it's a little difficult to read, but I'm happy to show you the photograph, and you can go out. Make your own cola product, and you'll have absolutely no difficulty, and Coca-Cola couldn't stop you because they didn't protect their trade secret. Now, of course, you can't call it Coca-Cola because that infringes their registered trademark. But as far as producing your own cola product using that particular recipe, no problem. So if you're going to go down the route of protecting your intellectual property by way of trade secrets, keep it a secret. A trade secret is only as valuable as long as it's kept a secret. Okay, 2 things to remember about patents and 2 things to remember about trademarks. Again, this is the most important aspect of the presentation. This is what I want you to all remember. So, you come up with an idea for a new product, a new service, a new business, something that may or may not be patentable, but you think it might be a great idea. What is the most important thing to remember? What should you always do? Well, keep it a secret. Keep it a secret until you have an opportunity to speak to a patent professional like me who can help you determine whether or not it's patentable and what you should do to protect it. Because if you don't do that, there is a possibility you will not be able to obtain patent protection in Canada, the United States, and elsewhere in the world. So any sort of offer for sale, any sort of public disclosure, a tweet, an Instagram posting, a white paper, a blog, a presentation like this, anything may possibly constitute a bar to you obtaining a patent. Even a casual meeting with your neighbor. If your neighbor or if the person you're speaking to, your potential investor, your banker, whatever, is not under a non-disclosure agreement, I'm sure those of you who are around here have heard what a non-disclosure agreement is. If you're not under a non-disclosure agreement, or as I like to call it sometimes, the cone of silence, if you're not under a non-disclosure agreement, even a casual meeting with your neighbor to discuss your idea could possibly prevent you from ultimately obtaining a patent. Because the whole idea of patents is we grant monopolies for things that are new. Okay, that's the whole deal. You disclose everything about your invention, and if it's new and if it meets the standard for patentability, we'll give you a monopoly for a certain period of time. But if you've disclosed your invention to the public, it's not new. And so therefore, you shouldn't be entitled to a patent. So that's number one that I really want you to remember. Okay, thing two, what's the second most important thing that I'd like you to remember today? It's all about the patent claims. Okay, well, patent claims, well, what are those? Well, if you read a patent, as those of you who come across a patent, well, what do you think a patent contains? It contains drawings of what the invention looks like. It contains a description of what the invention is about and how it works and how it can be put into a practice. And then there's these arcane words at the end of every patent called the claims. Okay? And the claims define the monopoly. The claims define the invention. So whenever anybody puts a patent in front of you, maybe they want to enforce it against you, maybe they want to get you to buy it, just read the claims. They're not that hard to understand. I call it the Goldilocks theory of patent claim drafting, okay? You don't want your patents to be too broad. You don't want them to be too narrow. You want them to be just right. If they're too broad, well, then they're not new. So they could be invalid. If they're too narrow, someone can design around them, and there's not much point having a patent if it's really easy to design around your patent claims. So you want them to be just right. Okay, what am I talking about when I talk about patent claims? Well, here's some arcane language. Let's see if in the audience you can figure out what this is. I always told you you're not supposed to read when you're giving a presentation, so I'll do my very best to, I can't memorize this. This is a computer-implemented method of controlling a portable electronic device comprising a touch-sensitive display, comprising a couple of steps: detecting contact with the touch-sensitive display while the device is in a user interface lock state, transitioning the device to a user interface unlock state if the detected contact corresponds to a predefined gesture, maintaining the device in the user interface lock state if the detected contact does not correspond to the predefined gesture. Finally, characterized by moving an unlock image along a predefined display path on the touch-sensitive display in accordance with the contact, wherein the unlock image is a graphical, interactive user interface object with which a user interacts in order to unlock the device. There, I read it all. What am I talking about? That's what I'm talking about. Okay, that is the patented claim for the unlock device that you see on your iPhones, and that is a patent claim for defining that particular invention. It's not too broad, it's not too narrow, it's just right. Okay, two things to always remember about a trademark. Now, I do a lot of work for Parmalat Canada. Parmalat Canada is one of Canada's largest dairies. I know everything about the manufacture, sale, and packaging of milk. So if you have any questions, come and talk to me. Lots of trivia. Fun fact: why is it we have milk in plastic bags in Canada, but nobody can buy milk in plastic bags anywhere other than Canada, and only certain provinces of Canada? I know the answer to that. I know all about that. So these are some of the trademarks of my client Parmalat Canada. I'm sure they won't mind. Lactantia, a very famous trademark for butter and yogurt. And there's a design, I'm sure so those of you have seen. There's some product packaging. It's a particular yogurt package. Look at that cow in the center. I believe it or not, I've spent many hours of my life on that particular cow and how to protect it and the like. Sounds and colors. Pink for home insulation. That's protectable as a trademark. That's pretty valuable. Now, take my word for it. I promise you I'm not going to take off my shoe, but I could. But here's a trademark that I think is kind of cool. The gold toe indicia on socks. Not the word gold toe, okay? The actual gold color indicia on the tip of a sock is a registered trademark. And again, I'm not going to take my shoes off, but trust me when I say those are the socks I'm wearing. When I go into a store, I like those socks. I look for that indicia. That's what connects me to the product. I have 3 kids. They're great kids. Two teenage daughters. What is it about the jeans and other clothes that they like at these particular stores that they always go to in the mall? What is it that gets them to get me to spend a lot more money to buy those jeans and other clothing products other than the ones that are a lot less expensive at other stores and other department stores. It's the trademark. Okay, it's the connection between in the mind of the consumer between the product and the quality and the source of those goods, and people will pay a premium, including fathers like me. Okay, so thing one that I'd like you to remember: always select a good trademark. So here's sort of the spectrum of protectability of trademarks, starting from very generic. That's a carpet cleaning company, not a particularly good name for a business or for a trademark, because it'd be really difficult to prevent some other carpet cleaning company from coming into business and competing with you. And it goes all the way down to the most distinctive Haagen-Dazs, which is actually a completely made up a trademark. I think the company's based in New Jersey, and it evokes, Haagen-Dazs ice cream evokes this sort of European, Netherlands, Dutch kind of thing, but really it's just a product that's produced in New Jersey. It's a very distinctive trademark, and as a result, they have a very broad scope of protection. So always keep in mind to pick a distinctive trademark if you can. And somewhere down the line on the suggestive side works as well, because you might want to evoke a certain sense of the quality or the nature of the product through the selection of the trademark. But the closer you are down the right side of that scale, the more protectable the mark is, and the easier it'll be for someone like me to enforce it for you. And then once you've selected your good trademark, you should register your trademark. Companies, including the teams that are here today, should give some serious thought to registering their trademark rights. Because if you don't register your trademark rights, you only get the ability to enforce it in sort of the narrow jurisdiction where you've used it. So a registration at the Canadian Intellectual Property Office will give you rights from coast to coast to coast in Canada, which can be very valuable. And a registered mark is a lot more valuable than a so-called common law mark, one that is only protectable and for which you only have rights as a result of use, as opposed to registration. Registration is not expensive, and as long as nobody opposes you, you won't have any difficulty. As far as selecting a good trademark, my war story there, those of you who live in Ottawa might be familiar with a gym that opened up some nice gyms across Ottawa, and they have a few in southwestern Ontario, called the Athletic Club. And unfortunately, they entered the market in Ottawa, and there was a company called the Ottawa Athletic Club that had been in business for about 50 years. And the Athletic Club, after spending, I'm sure, millions of dollars on signage and branding and marketing and the like, entered the market in Ottawa, and they were recently told about a couple of years ago by a federal court judge that they had to change their mark as a result of litigation by the Ottawa Athletic Club. So now, and here's my, other than that, here's my membership card to, it used to say Athletic Club, and now it says Movati Athletic. And that's pretty expensive to change all the signage and write to all your members and tell everybody you've changed your mark. And that's something that you really should try to avoid. So pick a good trademark, do a search, make sure you're not trampling on anybody else's rights, register your trademark, and you should be good to go. Okay, I want to move on to the notion of invention versus innovation. Adding value to change really is what I'm trying to get at here. So let's talk about the words invention and innovation are used interchangeably, and that's really a problem. So this is a picture of Humphrey Davy, I think I got that right, who is the inventor of the first electric lamp. So he's a great example of invention, something new. Okay, that's the change part. And the notion of invention is sort of taking some research and development dollars and creating something new, creating a new product or service, okay? But really the goal here is innovation, adding value to change. And the great example there is Thomas Edison. And we all know what kind of accomplishments Thomas Edison had with the light bulb and what he was able to form. He, of course, formed General Electric, one of the largest companies in the world, even to today. And so he adds value to change to make a marketable product or service. And that's innovation. And then the goal there is sort of taking what's new and getting a lot of money. And that's really what the goal should be all about. And that's sort of what we try to preach to our clients. The other metaphor that I've heard about, which I think does a really good job for me to sort of making me understand it. If you picture dropping a stone in the lake, that's invention, let's say. Let's call that invention. Well, the ripples that you see when you drop a stone in the lake, that's innovation. Now, what's the entrepreneur? Well, the entrepreneur is the person who looks at those ripples and say, hey, one of those can be a wave, and I want to ride that wave. Okay, and that's innovation. And of course, some of the greatest innovators are as we saw before, Steve Jobs, Elon Musk. I mean, these are people who really, they take something new and they create something better. They add value to change, and that's what this portion of the presentation is all about. So what we have here is a bit of a paradigm I'm going to focus on patents. As I said before, I'm a patent guy. The paradigm works for all intellectual property, trademarks, and copyright, but I'll focus on patents. And it's sort of a paradigm in terms of what I mean about how IP or how patents can improve your innovation. So of course, the first step is to create the technology, and we won't spend any time on that. The second step, and that leads to creating the patent. Creating the patent leads to using the patent. And through using the patent, there are certain goals, certain values we're trying to capture in terms of improving innovation. So we're talking about conflict avoidance and resolution. We're talking about market position, monetization, commercial leverage. We'll talk about each of those very briefly over the next couple of minutes. So I want to focus initially on creating the patent. And as you can see from this chart here, patents remain a core aspect to an intellectual property strategy. From 2000 to 2015, these are the number of patent applications filed in the United States Patent and Trademark Office, except for a little blip in 2007, 2008 due to the Great Recession. For the most part, they have been rising every year, year after year. If I had a chart and showed you a chart of filings of trademark applications in the United States Patent Office, it's the same trend. Okay? Protecting intellectual property is a major driving force behind delivering good innovation. So the whole idea is how to get the IP right by the right people at the right time and get it right. And so what I've seen over the years is a couple of errors in getting the IP right. First thing we see is where there's kind of not a meeting of the minds between the inventor and the person who's drafting the patent application, and you don't really protect really what you should have protected. And that's a problem, and you want to stay away from that. And then sometimes you see patents that are really just focused on what the inventor thinks the invention is, and that's not a good thing either. That leads to what the chart says is commercial irrelevance, and I agree with that. Really what you want to do is you want your patents and your IP to focus on the product that you're actually selling or that you intend to sell. You want to protect the commercial inventive feature, the thing that makes it special. And really what everybody should be aiming for here is the value proposition. Protecting through your patents, what is the value proposition to your customers and to your prospective customers? Because if you can tie that up with intellectual property, patents in this example, but it works for trademarks as well. If you can tie up and monopolize that value proposition, you can imagine how valuable that IP will be to your business in creating valuable innovation. So what do I mean by value proposition? Well, there's a few inputs, things you got to sort of think about when you're trying to decide about the proper value proposition, the so-called holy grail of IP. There's the technical inputs, technical aspects, what makes it technically better. There's also the sort of the customer inputs, what the customer is looking for. You want to make sure you've captured that. There's competitive intelligence. You want to make sure that you know exactly where your competitors are headed. It's that old Wayne Gretzky adage: you want to what is it? Skate to where the puck is going to be rather than where the puck is. You want to keep that in mind. What are your competitors up to now? Where are they going to be in 5 years? And how are you going to be 5 years ahead of them? There's sort of financial aspects. What's the value of the market, and what's the return? And of course, there's business aspects as well that you want to keep in mind when protecting the value proposition. What's your exit strategy? Are you going to go IPO? Are you going to sell? You know, how are you going to make this IP that you're developing valuable to the company, and to move forward? So in terms of the value concepts, I want to talk a little bit about conflict avoidance and resolution. People, companies, medium-sized and large-sized companies especially, they stockpile patents and trademarks, but mostly patents, in order to, believe it or not, to avoid conflict. So they will resolve conflict. And some of the examples that I have up here on the screen, the various pieces of litigation that are referred to up here, you know, are examples where unfortunately that didn't work and somebody was made to pay a lot of money. The conflict just couldn't be avoided. So instead, what you want to think about is developing an IP portfolio that in fact creates sort of a whole bunch of deterrence. Okay, that's what the goal here is to create deterrence. So what am I talking about? I'm talking about deterrence for competitors to enter your market. I'm talking about deterrence for competitors to enter, to sort of obtain financing. I'm talking about deterrence to prevent your customers and prospective customers from adopting somebody other than your technology. My favorite one is patent applications can have a speculative deterrent value. I'm a real patent geek, and one of the things I do is I read a patent blog every Tuesday morning, because in the US all patents are issued at 12:01 a.m. on Tuesday morning. So there's a blogger who blogs about Apple's latest published patent applications every morning, Tuesday morning, and Apple files patent applications for just the coolest, strangest stuff that you're never going to see in a smartphone, or you don't think you're ever going to see in a smartphone. Of course, you don't know for sure. But I think at least they do that at least in part for this last bullet point here. It's deterrent value. By creating this minefield, this patent thicket of all sorts of different things that are going on with the smartphones, they create sort of this automatic deterrent value for a competitor or a prospective competitor to enter the market in that particular area. So that's kind of cool. Let's talk about market position. This is sort of graphically illustrating sort of the revenue model for a typical product or service. You know, it has a certain peak after a period of time, number of months, number of years, and then of course the number of years across the x-axis demonstrate, you know, the kind of sustainability that we're talking about in terms of the product or service. And of course, after peak, you're going to get competitive pressure, which is going to keep your margins down. That's the typical unpatented product or service. The whole idea of obtaining patent protection is in order to get a price premium for the product or service, which will increase your profits and move the competitive pressure back. If you do it properly and do a really good job, you can move the competitive pressure back even as far as that. And of course, that yields extra profits. And that goes straight to your bottom line. Of course, at this point in the market, you know, all your R&D has been paid for, and everything you see in the graph there is added value to added profit to the company. Some of you, I'm sure, have heard of the expression patent cliff. You hear that a lot with pharmaceutical companies. And that's what I'm talking about here. That's where the patent protection expires. So you see that on some major pharmaceutical products. And then competitors can enter the market, and there's sort of very quick, swift competitive pressure. It brings prices down, usually to the benefit of consumers, of course, and which of course affect profitability. Monetization, just a couple of words on that. you have to think about your IP as property, okay? So with any form of property, you can sell it, you can license it, you can monetize it in a variety of different ways. You can value it. It goes, it can be valued there are companies that IP valuation companies that will help you increase the market value of your company based on your IP. And there are certain tax advantages in certain provinces and the like to investing in IP. Commercial leverage, how to use your patents to maximum commercial leverage, certainly enforcing it against direct competitors, would be an example of unilateral competitive leverage. Bilateral competitive leverage examples there would be sort of cross-licensing. You'll see companies say, okay, I won't sue you if you don't sue me. We'll enter into a big cross-licensing agreement for all our patents, and that's an example of bilateral commercial leverage. And multilateral commercial leverage, there's patent pools where companies, large groups of companies in particular industries get together, they pool all their patents together, and they all agree not to sue each other. So that's an example of that. So these are the sort of the values that you're trying to capture to improve innovation. It gives you an example of how patents or trademarks can improve your innovation. And again, add value to change. So what's next? Where do I conclude? Well, the message I'm trying to give you here is to build a valuable intellectual property portfolio, in order to, improve innovation. And how do you do that? Well, you typically work with service providers who deeply understand your business. They're not just out to look at the right sort of the intellectual property right we're talking about sort of on its own. You want people for whom you have a deep working relationship with, and usually a long-term business relationship. These are the kinds of things that fosters, in my experience, the greatest opportunity for innovation. Happy to answer any questions afterwards about anybody has any questions about IP, about patents, trademarks, anything and the like. It's been a pleasure. Thank you very much.
Hi, I'm Amber Mack, and if you like this video, click to subscribe to the Breakout Project channel to watch more videos just like this one.